Otherwise law-abiding UK citizens are being arrested again for supporting Palestine Action after the Court of Appeal reimposed the Labour government's ban on the organisation. One can understand the court's position because its decision to reimpose the proscription of Palestine Action as a terrorist group is based on the current UK definition of terrorism. That definition, found in the Terrorism Act 2000, states that terrorism constitutes actions involving serious violence, serious damage to property or risk to life, done for a political or ideological cause, with intent to influence government or intimidate the public. That is a notoriously wide catch-all definition. The court actually said that the Home Secretary has wide latitude when deciding to prescribe groups, and the High Court had materially understated that latitude in lifting the original prescription. In other words, the court's ruling confirmed that the breadth of the definition is intentional. Judges said the Home Secretary is best placed to assess future threats and risks, and when balancing rights against national security, the government's assessment outweighed protest rights. This is consistent with judges' normal behaviour, because courts are generally reluctant to substitute their own judgment for that of ministers on national security matters. The court also stated, Palestine Action overtly promotes unlawful violence amounting to terrorism. It highlighted property destruction, injury to human beings, the group's organisation in a series of covert cells, and its intent to disrupt armed factories for political ends. I'm not going to argue with the facts of Palestine Action's behaviour, although I would point out that the organisation has always stated that it has never intended to cause injury to human beings. But I would question whether the government has used the wide breadth of the definition of terrorism and the Home Secretary's latitude when deciding to prescribe groups to strike a political blow rather than merely make a legal ruling. The activities for which Palestine Action was originally prescribed arose from its members' perception of the Israel-Gaza conflict as a genocide, in which the government had allowed the UK to become complicit. This complicity was demonstrated, they would argue, by the government's decision to allow military parts manufactured in the UK to be shipped to Israel to become part of that country's massively superior arsenal for use in that conflict. They believe that this amounted to UK complicity in genocide, a genocide that is ongoing, by the way. Israel has continued to attack despite a ceasefire in late 2025, killing hundreds of civilians. Almost 9/10 of the population has been displaced, with widespread food insecurity and inadequate shelter. The health system was systematically destroyed, according to UN experts, and humanitarian aid is far below required levels, with Israel denying medical aid to Palestinians by closing or restricting access to crossings into the territory. The result is that Israel has made Gaza functionally uninhabitable. Attempts to persuade successive UK governments not to support Israel's offensive that has murdered many thousands of civilians in Gaza, including women and children, fell on deaf ears. In the light of this stonewalling, the members of Palestine Action decided to take action of their own, and have been supported in doing so by many members of the public who also believe the UK should not support what they see as a genocide. But anybody showing such support is liable to face arrest themselves under the Terrorism Act. As The Guardian's article last week states, the Metropolitan Police has arrested over 3,000 people on suspicion of expressing support for Palestine Action, with 117 people protesting outside the court building when the judgment was handed down, now added to that number. More than 700 people have been charged under Section 13 of the Terrorism Act, under which they face a maximum of 6 months in prison. Is the government really trying to say that such a number of otherwise lawful citizens are now terrorists, or at least supporters of terrorism? Alternatively, and this can exist alongside the government's claim, is it more likely that once a group has been found to have committed politically motivated criminal damage and violence, it is too easy for the government to brand it terrorist? The judges themselves appear to have recognised part of the difficulty when they acknowledged that Palestine Action engages in both peaceful and non-peaceful protest and enjoys support from many otherwise law-abiding citizens. And they did not say those supporters are themselves terrorists. Their conclusion was not that the group is equivalent to every organisation on the proscribed list, but that its conduct was only sufficient to bring it within the legal framework Parliament has created. The question now is not whether the government was right to prescribe Palestine Action under the law as it stands, but whether the statutory definition of terrorism needs to be so wide that it made that prescription possible. Limiting its latitude would have the support of many organisations, including Liberties, Human Rights Watch, Amnesty International UK and Greenpeace, and is likely to be the question underlying any appeal to the Supreme Court and, ultimately, the European Court of Human Rights.